Right now we will look at how the judiciary has reviewed the functioning of information commissions, either at the state or the center level, in trying to understand the powers and functions that they can exercise. What is the scope, what is the ambit, and what are the limitations on the powers and functions of the Information Commission. So to understand this, probably we'll have to discuss a couple of cases and try and see where the judiciary has stepped in to draw a framework within which the Information Commissions can work under the Right to Information Act of 2005. The first among the cases that we have is a case that was decided twice by the Supreme Court of India, and the title of this case is Namit Sharma versus the Union of India. In the first case, as I told you, there are two cases that the Supreme Court has decided. One was a review of the first case, and the Supreme Court had to state what the judges in the first case did was right or wrong. However, let us start with the first case, and in the first case, you will notice the constitutionality of Section 12 under the RTI Act and Section 15 were challenged. Now, as we know that Section 12 and Section 15 are very relevant in looking at the powers and functions of the Information Commission, and these two sections lay down those powers and functions. In particular to Section 12.5 and 12.6, it was argued that the Information Commissioners so appointed are discharging quasi-judicial and judicial functions, and hence, because they are dealing with law, they are dealing with justice, they are dealing with adjudication of disputes, they ought to have a judicial approach, and hence those who have some experience, knowledge and expertise in law, and those who have some kind of legal acumenship should occupy the position of the Information Commission. Now, the aspect is that Information Commissioners unfortunately have been appointed from various backgrounds. As I told you in the previous discussion, some of the Information Commissioners had a background from journalism. Many of the Information Commissioners happen to be ex-bureaucrats, having served in the government for their full career. Quite a few Information Commissioners had a background from civil services. They had background from police services. There were Information Commissioners who had completely a non-government background. They were activists, and hence they were given the appointment of being an Information Commissioner. However, no former judge had ever occupied the position of an Information Commissioner, which means nobody from the judicial service, nobody from the background of being a judge was ever given the appointment of an Information Commissioner. And I think in Namit Sharma case, this was highlighted, saying that in case the Information Commission is discharging judicial or even quasi-judicial functions. Why? Because the powers are similar to that of the court in issuing summons, recording evidences, calling for documents and records, and adjudicating on the right to information, which is a right that is granted under the law. Then they ought to have some kind of experience, knowledge and expertise, or some kind of legal acumenship that is very relevant and important. And hence, these things not being provided in Section 12 meant that Section 12 was not adequately drafted. It did not represent the vision of the Constitution. And hence, what was petitioned to the court was, please declare Section 12, 5 and 6 as being unconstitutional, because they don't reflect the aspiration of the Constitution in equipping the members of a quasi-judicial body with legal skills, with legal knowledge. The Supreme Court, in the first case, as I told you, there are two cases to this, but in the first case, clearly was convinced of the fact that Information Commissioners should have a legal background. They were convinced of the fact that Section 12 did not adequately provide for the same. And they were convinced of the fact the process of appointment of non-law persons as Information Commissioners has affected the working of the Right to Information Act. And hence, what they held was, they read down Section 12 and they said that Information Commission is a judicial tribunal, and it is adjudicating disputes under the Right to Information Act. It is supposed to perform a judicial function, and if it is to perform judicial function, the commission, they said, must comprise of two members always. One should be a judicial person who has some degree of knowledge in law, who should have legal background and should be judicially trained, or at least should be a lawyer who has practiced for a period of not more than 20 years, for at least a minimum of 20 years in that sense. And he could also additionally have some experience in social work. So the Supreme Court, by the Namit Sharma versus Union of India case 1, clearly paved the path for one, holding the Information Commission as a judicial tribunal. That was a significant move. Secondly, also insisting that the judicial members should be appointed to the Information Commissioner, or there should be persons who have degree of law and social work, and should have been at least trained as a lawyer. And I think what the Supreme Court did was, they said that the Information Commissions play a very pivotal role in legal interpretation, in legal application, and hence without a legal mind, without a judicial member, this task or this function cannot be adequately addressed. And hence it was imperative to read down section 12 and to include an amendment which will allow judicial members to be appointed to the Information Commission. So any lawyer who has practiced for a period of 20 years could also be appointed if he has an additional experience in social work. So that was also left open, saying that it is not only for judges or judicial officers to whom the Information Commission can make appointments to, but it can be a lawyer with that minimum experience as well, is what the court had to say. The Supreme Court also went ahead a step forward and also said that the appellate authority should be a person trained in law. This is the first appellate authority who happens to be a senior in the organization, who heads the public authority, who hears an appeal from the public information officer, and hence the Supreme Court also additionally concluded that let the appellate authority also have some training in law, and that could be a qualification, prescription of a qualification for who should be an appellate authority. Unfortunately, the prescription of an appellate authority is not there in the RTI Act. However, this case probably puts that into the forefront. Finally, I think what the case says is that the appointments are made by the President. However, it is made by a committee of the Prime Minister and the Leader of the Opposition and a Cabinet Minister. And it is probably an appointment that is made by the government in tune with the opposition leaders. And hence there was a kind of only an executive voice in the appointment of the Information Commissioner. So the Supreme Court then says that to bring in quality, merit, and some kind of neutrality to the appointment process, they said that such appointments from henceforth should be made in consultation with the Chief Justice of the Supreme Court in the case of Central Information Commission. In case of the State Information Commission, the consultation should be with the Chief Justice of the concerned High Court, as the case may be. So I think the Namit Sharma case in 2012 laid the path for judicial application in the functioning of the Information Commission. And I think that was a very significant judgment that did come across, holding the Information Commissioner as being a judicial tribunal. Finally, the court held that Section 12, 5 and 6 were ultra-virus. The Constitution does not display the objectives and the purpose of what the Constitution talks about: a clear separation of power, independent and autonomous to judicial and quasi-judicial institutions, is what the court had to conclude. However, the Namit Sharma case 1 was challenged in a review petition, stating that the judges in this case committed an error apparent on the face of the case. This was filed because one, there would have been a huge difficulty in amending the law, huge difficulty in finding the concerned legal judicial members, because the information commissioners should be equipped with so many people, and to a larger extent, I think the government wanted a review of the directions given by the court in Namit Sharma case 1. So the review petition was filed, and the Supreme Court in the review petition completely reversed the Namit Sharma case 1. they found the case having decided on wrong grounds, and they did first start by holding this. The Supreme Court in the review petition held that the Information Commission does not adjudicate a dispute between two or more parties concerning their legal right, other than just the right to get information in possession of a public authority. So it was not interpreting any fundamental right. It was only talking about some right to information which is in possession of a public authority. It's not necessarily an adjudication of rights in that sense. And hence, the Supreme Court said that the Information Commission is not a judicial tribunal, however, is performing a function as an administrative simpliciter. So it is an administrative decision which ought to have been taken whether the information should be given or shared or not, and hence it is not a judicial function. It is an administrative function, and hence the Information Commission do perform only an administrative role and not a judicial. So this is the first basis for a distinction to be made in the review petition. Second, the court held that it was for the Parliament to decide and consider whether a judicial member will improve the conditioning of or the functioning of the Commission or not, and it was not for the Supreme Court to lay that down. So what the Supreme Court in this case did was they decided that it is not their business to prescribe the qualification. It is not their business to suggest that a judicial member will improve the functioning and have a judicial mind and a judicial approach. It is for the Parliament to finally decide, and it was not for the court to decide. And hence the court said, if the Parliament has decided that this is the necessary qualification for the Information Commission and there is nothing wrong in that prescription, the Supreme Court should not have intervened in that matter at all. And hence the court reversed the Namit Sharma case, which required a lawyer or a judicial member to be appointed to the Information Commission, and the Supreme Court also held that the Information Commission is an administrative simpliciter organization and is not a judicial tribunal. So it's a very significant judgment. The Supreme Court of India, though being the apex court, has two contrary views completely opposite to each other. But I think the review petition view is to be taken into consideration with the fact that I think framing a law and framing the prescribed qualification for members to be part of a quasi-judicial tribunal is completely the discretion of the Parliament. It is completely the discretion of the legislature. And I don't think the judges should bring in an element of creating some space for them to occupy as judicial members once they are retired, so that they can occupy and become information commissioners as well. Also the fact that it is not interpretation of legal rights, it is just an application of information vis-a-vis a public authority, and hence it is some kind of an administrative process within which the PIO, the Appellate Authority, and the Information Commissions are involved. And that very clearly depicts the changing view or trend of the Supreme Court in lack or in terms of non-interference with the parliamentary functions in framing a law or in legislating a law. However, there are certain issues for discussion from this case that one should seriously consider. For me, I think when we have spoken about constitution and right to information, and we have spoken about the Rajnarayan case, the SP Gupta case, the LK Koolwal case, and so many other cases in which we have held the same Supreme Court to come to this conclusion, saying that the right to know or the right to information is an integral fundamental right under Article 19(1)(a). And being a fundamental right under Article 19(a), now getting incorporated as a statutory right under Article the Right to Information Act 2005, should one think that the denial of the same should not be adjudicated through legal and constitutional nuances? I think when you talk about a statutory right, I think it's a right. If the denial happens, I don't think it's just an administrative action, I think it's a judicial action. I think without judicial mind, how can legal and constitutional aspects be applied in the RTI legal regime? I think that is a huge challenge, isn't it? So the genesis of RTI is in the Constitution. The genesis of RTI is through the right granted through the Statute of 2005. And this requires legal interpretation, it requires a legal mind, is what one would want to argue for. And hence, without the judicial mind, how do you expect the Information Commission to perform its role? Second, I would always say that if there are judicial members that are appointed to the Information Commission, it would create a sense of independence and judicial autonomy, which is very important for the functioning of the Information Commission. If the Information Commission is just an extension of the bureaucracy, it is those bureaucrats who after retirement and who have served government for more than 30-35 years become Information Commissioner, then to that extent their position of independence and autonomy is often challenged. So if you have judicial members, that sense of independence and autonomy can be enshrined, can be probably secure, and hence I think having judicial members becomes inevitable in those circumstances. And hence I would urge the government to think about the possibilities of appointing judicial members within the framework of Section 12, Subclause 5 and 6 itself, and not only look for bureaucrats or government officers. I think in the review petition, the court states that the Information Commissions can hear complaints, hence are performing just administrative functions. That is true in terms of Section 18 of the RTI Act. How about Section 19? See, Section 19 speaks about appeal functions, and an appeal function in a body like the Information Commission is before any kind of adjudication is taken either to the High Court or to the Supreme Court. And hence, when there is an appeal function under Section 19, is it not a judicial function? And shouldn't the court have taken that into consideration as well? I think every part of an appeal function is a judicial function. And when you say the Information Commission is having all the powers that a civil court has, now the exercise of those powers of the civil court is not necessarily an administrative role, it is a judicial function. And it's a quasi-judicial function, that is something that the Information Commission is entitled to. And hence, I think these are the three important issues that can be discussed as an implication of the Namit Sharma case 2. And probably it is for the government to decide about changing or amending the law. I think that is something that is very relevant, and that is something that should be the outcome of the case discussion, simply because of the fact that it is not for the Supreme Court to decide the qualifications and the merits of appointment. It is for the Parliament to lay it down. And that kind of judicial non-interference is probably well appreciated in the Namit Sharma case too. Finally, most important, I think when a public information officer is imposed with penalties under Section 20, I think penalties have very serious consequences. It's a fine that is being levied individually on public information officers, and that is of a serious implication. It's like a punishment. And according to me, when there is imposition of penalty, trying to adhere to the mala fide intent or to the deliberate intent on the PIO, finding evidence relating to the same and justifying the same, I think is definitely a judicial function. And this has to be taken note of the fact that when an information commissioner decides to impose penalty, if he does not adequately justify the same, we have seen how high courts have intervened in those matters and have actually rejected the penalties being imposed by the information commissioners.